after it's sold? Does this apply to indoor residential crops? If you buy a house and they left the plants, can you just throw them out? Any environmental or legal issues in doing that?
No.
No,
As
it's
far
a
as
plant material.
Yeah. As
I
far
mean,
as
you
we're
may not
concerned.
want to be caught transporting it if you don't have the proper documentation from the state. So again, it's probably best to call local law enforcement if you come across abandoned marijuana in a residence, and let them dispose of it for you.
Yeah, and from a best practice for realtors kind of standpoint, I mean, if there's a grow facility in a house that you're closing on behalf, if you're representing a buyer and closing on a house where there is an existing grow facility, it's something you're probably going to want to address prior to closing. I mean, that is. I think some of your question has to do with growing crops. You know, the crops, in many cases, the grow lights, the hydroponic water systems, that stuff is probably going to be personal property, and that's going to be removed by the seller at closing. But if you're in a situation where you get a buyer and somebody's leaving that kind of personal property behind, you're probably going to, hopefully you would have addressed that before closing and it would have been removed. And if not, then it seems like, you know, it is stuff that you could get rid of. And if you've got concerns about it, then maybe do contact law enforcement to have them give you some direction and guidance on that. Can we copy this recording to be used to inform our county and city officials? Well, there'll be a link for this, so you have access via a web link, the same one you used to get in here, and so you know, there's no. You feel free to distribute it to, you know, friends, colleagues, government officials, that sort of thing, if you'd like to. Can leases contain enforceable wording so that an individual who has a prescription from a doctor cannot grow in the house or on the property?
The wording, you need to be cautious with the wording because people have the legal right to grow marijuana according to Amendment 64 and Amendment 20. But you have to be cautious with that wording. You can't just be specific about marijuana itself. You need to be specific with, you know, vegetative flora. There's certain words out there. I've seen multiple contracts, rental contracts, and they all have different varieties of words. But obviously, I would get with an attorney, a real estate attorney, for specific verbiage within the contract.
Remember, if you're some rentals have no dogs allowed or no pets, you can certainly, I think, get with your attorney, but I would think it would be reasonable. You could say no growing of marijuana inside of the residence as well.
Yeah, I can give a little bit of feedback on that. You know, marijuana users are not a protected class, even if it's medical marijuana. Protected classes are established by the federal government under fair housing, or the ADA would establish disabilities. The ADA doesn't provide anybody with the ability to use marijuana for medical purposes. And so you can discriminate against a marijuana grower or user in the rental of your property. And so you want to be cautious with the language that you're using to make sure that it is ultimately enforceable. But yes, you can, whether it's for recreational purposes or medical purposes, as a property owner, you can, through the lease, preclude your tenants from, you know, using, growing, or possessing marijuana. What can be done by local governments to stop this before it started in smaller communities? Again, I think it's a matter of, you know, legislative initiatives and efforts to try and control that, possibly through your city, on a local basis, through your city council or local boards, depending on, you know, how your local municipal government's structured. But it would be but it would be through them.
We do know that some cities and counties have actually enacted ordinances limiting the number of plants that can be grown inside of a residence to 12, providing for the 6 medical marijuana and 6 recreational if you're over 21. So there's a number of cities and counties that have employed that number of 12.
Yeah. So next question is, how do we address questions from buyers where homes were potentially grow operations? For example, there was excessive wiring, lighting, ventilation, maybe even mold present. Can we refer the buyers to an organization or the police to investigate? How do we protect ourselves from liability as a realtor? I'll take the last question. I'll let you guys maybe address how do you identify it, and can you refer to the police, to a police organization to investigate?
So as far as referring to a police organization, you can if you suspect that there was a grow there. It's not a guarantee that you're going to get the response that you want, but once again, that'll reflect back to to resources for that we have within the departments. But you can definitely call and request somebody to come out and take a look at it. But I don't know how to.
Yeah, well, so home inspector is going to be looking at that. I mean, if so whether or not it was a grow facility is certainly one part of it. Again, the big issues that I think as representing a home purchaser, as a realtor, are going to be what was done in terms of modifications made. Was it done properly? Was it done pursuant to code? Are there fire issues or electrical issues because people have created additional panels and that wasn't done by an electrician? Was there standing water such that mold was able to accumulate somewhere? So those are sort of home inspection issues that I would say, again, regardless of whether it's marijuana or other concerns about the habitability of a property or the condition of a property at closing, if you suspect or if there's reasons to suspect that it was a grow facility or an extensive grow facility before, then I think that's something you're going to want to have a conversation with the home inspector about, and to the extent that they are not able to give you some recommendation or determination on what the risks are, then they certainly ought to be able to point you in the direction of an expert to kind of take that inspection to the next level if it's a big concern for your buyer. How do you protect yourselves from liability as a realtor? I think if you have that suspicion, you probably want to send something to your buyer in writing that says, listen, as we've discussed, or as we discussed at the property, we have this suspicion that it is that this basement was formerly a pretty extensive grow operation. Per our discussion, I would say, let's try and contact an inspector to look at this. Let's take that inspection to the next level and bring in potentially an electrical contractor, or a mold inspector, somebody that can drill down on some of the more specific issues, but put it in writing. I mean, that's what ultimately, if your buyer comes back to you after closing and they say, oh, geez, this was a grow facility and we would have never closed on this house if we had known, you're going to feel awfully good when you can pull that email that you sent out of the file and say, well, we did talk about this, and I even sent you this in writing to disclose that, you probably ought to take some additional steps. So I think that's putting things in writing and having the discussion is the best way to protect yourself from liability if you're representing a party like that, or a party that's buying on a house like that. I'm dealing with a neighbor who's currently growing in his crawl space. I've made several complaints to the police and the HOA board, who've done nothing because they say that he is not breaking the law. The smell is coming into my condo through the ventilation system and affecting myself and my kids. Is there anything I can do to get him to not be allowed to grow, since it's a common area / space that we share?
So depending on where you live, your city, county, I can't even talk anymore. Municipality, thank you. Depending on where you live, there's if they have codes for that within city codes, or if they're ordinance codes for the fact of odor control, things like that. So it's difficult to answer without knowing exactly where you're at or what their rules and regulations are for that city or county.
I think City of Denver just passed some sort of odor ordinance.
City of Colorado Springs did as well.
Yeah, and I would have a conversation with your board. I mean, if you're in an HOA, you've got a board, you've got rules and regulations, you've got condo documents that essentially govern what people can and can't do on the property. There's very likely some generic sort of statement related to having illegal activities on the property. It's possible to potentially enforce something like that if it's affecting other homeowners. And then there's also the habitability stuff. I mean, if they're affecting your use and enjoyment of the property, then your HOA has other rules and regs that you could use, particularly as it comes to noxious odors and those kinds of things that are coming into your property and having an impact there. So,
and if not, your HOA can create those rules, but they'll need to do that through the HOA attorney as well.
Yeah. So, really good question here that I think is important to address. If a landlord is unfortunate enough to rent to one of these entities that turn the house into a grow house, do you know if the damage would be excluded since it was caused by illegal activities? This is in terms of insurance coverage.
I know that most insurance companies have in regards to mold, they do not, settle any claims regarding mold, regardless how it's caused. But we are reaching out and have met with several insurance companies, and they are now looking at what they should be putting in their new insurance policies as a result of this kind of new phenomenon that we've been experiencing.
Yeah, and so again, this gets back to this kind of conflict between federal and state law that we've got going on. Insurance companies are going to be adhering to federal law, and most of your property insurance policies currently have riders that make a generic reference to excluding coverage for casualties based on illegal activities. And again, under federal law, marijuana use, possession, growth is an illegal activity, and so it is very possible that a property insurance company could deny coverage for casualties that are based on illegal activities at the federal level. What can HOAs do about marijuana grows, legal or not, especially when the HOA is responsible for the outside of the units?
It's the same thing. They need to draft up ordinances for the HOA, obviously through the attorney and through the board, what they find is relevant for the area that they're living in.
Yeah, HOAs control, you control your bylaws, you control your rules and regulations within the community, and as a board, as a member association, you have the ability to go through your procedures to enact changes to your bylaws and rules and regulations, and to the extent that you can get the sort of groundswell or movement from the rest of the community, then you can certainly prohibit these types of activities. Why are we not changing laws to lower the amount of plants allowed per household? Also, what causes a CO level in a property to rise with the grow facility? You guys want to address?
I'll let you take the the plant count one.
Yeah, with the plant counts, I mean, that was something that was put into the original amendment, Amendment 20, which said as 6 plants as well as any other plant count deemed by a physician. The reason my belief is the reason they set the 99 plant limit is because under federal law, 100 plants is a 5-year minimum mandatory sentence. So I think they did not want to attempt to antagonize federal law with that, so they stayed at 99 plants. But again, I think some of the city and county ordinances trying to limit grow locations to 12 plants. Hopefully that helps, but again, those are mostly civil ordinances, not really criminal in nature. So how effective those are is kind of remains to be seen.
What was the second part of
It was what causes the CO level in a property to rise?
So the plants need obviously oxygen to grow, but when that's depleted, they're supplementing it with CO2, and those are some of the dangers that we come across. But I don't know how to best to answer that. I mean, the levels of CO2 become dangerous at about 50,000 parts per million, and that's within a residence. We don't have the tools as law enforcement to be able to measure all of that stuff at this point. I know fire departments do, but we don't.
And typically when we go in, we vent the home right away to kind of lower those levels and make it safe for ourselves. But there is a significant rise in CO2 levels in these residences.
I get a strong headache when I go into most residential grows just because of the high CO2 levels and not being able to know where they're at. It takes me several hours to get rid of a headache because of that.
Yeah. Yeah, in terms of what actually causes the CO level to rise, I'm just a simple lawyer, and I skipped that day of my biology class in high school, unfortunately. So are home inspectors being exposed to this information in any capacity? I'll just say that, I think they're all aware of it because it's a very common thing that's going on, as we've seen across the state. And so they better be looking for it. I think they have an obligation to look for it and be paying attention as to, whether there are, again, things related to marijuana grow that have an impact on the physical condition of the property. And so I think they're aware of it. We at the association, we've advocated with other parties to license home inspectors, and the legislature hasn't seen fit to do that. But to the extent that there's some licensing framework put on that industry, it potentially would be easier to set standards of education on issues like this for them. So a couple more questions here. There have been many busts in the Pueblo area recently. Are there just as many grows in Colorado Springs that just haven't been busted yet? Or is there any reason why Pueblo has so many? I know where that question is going, is to Detective Hughes from Colorado Springs.
So two parts, yes. There are just as many, if not more, grows in Colorado Springs. Pueblo County has been very busy. Some of the differences between Pueblo County and what Colorado Springs are at, and as to why some of them get busted compared to ones that don't. Currently in El Paso County, we have over 19,100 and I want to say 40 registered medical marijuana patients. So that means there's over 19,000 people that carry a medical card saying that they can grow 6 plants on up to whatever their doctor recommended. In Pueblo County, there's a little over 3,000 registered patients with it. So there's, a huge difference between going and talking to somebody for a compliance check and they show you their medical paperwork compared to going to somebody in a residence that doesn't have it and they're claiming medical but without the proper medical documentation from a signed physician. So yeah, it's big. It's huge across Colorado Springs as much as it is Pueblo and Denver and throughout the entire state.
It's big all over. Let's see, just two last kind of questions or comments. The legislature, why is Colorado so lax? The legislature is moving to close the loopholes that are, is the legislature moving to close the loopholes that are being created by all of the illicit activities? Agent Merrill?
I would just say that we really noticed this uptick, and there's always been indoor residential marijuana grows, but the last 2 years we've seen a significant increase, and I believe it's directly attributed to the 99 plant count growth, as well as these organizations who come from the East Coast thinking that there's lack enforcement. The laws have loopholes in them. The regulations, again, there's MED who does not regulate these indoor marijuana grows. So I think that's all attributed to the problems, kind of some of the unintended consequences of passage of Amendments 20 and 64.
Yeah. If you think about it, in addition to the perception that there's going to be lax enforcement, and because there is this conflict between state and federal law, these people will come from other states to grow here because of their belief in that. But aside from that, they also have a lot more resources here because of the proliferation of marijuana grows. They have parts for their grow. They can buy grow lights. They can buy proper fertilizers. They can buy seedlings and other plants. I mean, they have the resources to perform their businesses, and so that's another reason that it's so attractive for them to come here because we have legal resources from a retail or supply standpoint that just they don't have in other states. And then the last question kind of comes back to this property disclosure. How long must a property owner disclose the fact that a marijuana grow facility exists in the property? Again, it is not a mandated disclosure unless it has implications on the other already mandated disclosures. So electrical modifications, plumbing, mold, structural presence of herbicides and pesticides is on the seller property disclosure form. So those kinds of things, if the marijuana grow activities give rise to those other disclosure items, then you would have to disclose issues with those other items. But in and of itself, simply growing marijuana is not a mandatory property disclosure. Another part of that question is I've taken a class on this topic presented by an attorney, and his recommendation was to just treat it the same as a meth lab. Do you guys have any thoughts or feedbacks on that?
We believe the marijuana grow houses these days, especially the large marijuana grows, and mind you, this is not about the person that has the 6 plants in their house. This is about the person that has 50, 100, plus plants in their house. But we're looking at them as the new meth labs just 10 years later. We're not seeing meth labs anymore, but the grow houses, we believe, are just as dangerous because of the unknowns that are in there.
Yeah. So, in terms of treating it as a meth lab, while it is not a mandatory property disclosure, like certainly meth would be, absolutely that's a mandatory property disclosure. If you're representing a seller and they've had a grow facility, it may make sense for them to disclose that. They certainly can, from a voluntary standpoint, disclose that. And as the sort of cardinal rule of real estate goes in terms of disclosures is disclose, disclose, disclose. And so the more information you provide a prospective buyer about activities that have occurred on the property previously, the better off theoretically they are if there are issues at some later date. So anyhow, that covers the questions. I want to thank Detective Hughes and Agent Merrill for taking the time to do this. They've done this in a number of other places around the state, and really for informational purposes, it's just so important to know what could be occurring in the house that you live next door to, across the street from, and in the case of realtors, the house that you're representing parties in purchasing and or selling. And so I think it's really good information, and I hope you guys found it to be informative and useful. And again, thank you, gentlemen, for your time in doing this, for your efforts around the state, and for your service in law enforcement. I think we all benefit from all of your efforts and your agency's efforts, so thank you very much.
Thank you.
Thanks for joining us.
All right.
Hello, my name is Margaret Williamson. I am the Professional Development Coordinator here at Colorado Association of Realtors. We want to thank each of you for joining us today. Be sure to check the CAR website for more webcasts being added to the schedule and to register for these events. Visit us anytime at coloradorealtors.com. With that, we hope you enjoy the rest of your day, and remember, knowledge happens here.